everything is fine on your side.
We are all doing well. There are many concerns that have been expressed about the Supreme Court's intervention and the manner in which they did it. Do you agree that there are many things to be concerned about, especially the haste and the speed?
You know, when it comes to the speed, I always say that all of us are really trial. And most of the time, when you hear concerns from the public, it is about the sluggish nature of proceedings in the court. So, on a normal day, we should all be clapping for the Supreme Court for the speedy nature in which they handle this matter. And indeed, if we are guaranteed that from last Friday onwards, all cases will be handled with such dispatch, we should be happy. But I think the problem which many people have, and which I believe is causing you to ask this question, is the fact that there are equally or even more important cases or urgent cases which have been lying in front of the court for months, sometimes years. And so then the question is, what is so special about this particular case? So the question, I think the issue really is not about the speed of how this case was decided. It is about why this case was decided with such a speed, while other cases, which are probably even more urgent, have not been decided with such a speed. And this issue came up again at the LGBTQ, the case that was pending about the LGBTQ. So you would, it creates an impression. There is a consistency in this behavior, where when it appears that Parliament has an issue with the executive, the Supreme Court is always in a case to hear, and all the time, find fault with Parliament. So they hear cases concerning Parliament so quickly, and in all the cases that this has happened, it appears that they find fault with Parliament. The LGBTQ situation, we have two cases. One which seems to favor the Parliament, and the other one which seems to favor the executive. Even in that case, the Supreme Court heard the one that was looking for fault in Parliament, and gave a ruling which was against Parliament. So the reason why people are concerned about the speed is not that people don't like speed. It is because the speed seems to be taking a particular direction, one that favors the executive or the current NPP government, and against the legislature. So putting it into the proper context, the problem is not with the speed, but it's with the fairness in which the speed applies. And that is what we should understand. And of course, I personally don't have a problem with the speed, but I have a problem when the speed is not taking a fair view of all the cases before the court.
Well, but having said that, then what do you make of the decision the Supreme Court has made? There are many people who have described it as an unnecessary intrusion into the work of Parliament. Do you agree?
I support that view strongly. First of all, let's begin with what we call the separation of powers. The concept of separation of powers, which we see today and which we seem to be practicing, comes from the American, when Americans were under British rule. And in Britain, they have a body called Parliament. The British Parliament is not the same as what we call Parliament in Ghana. In Britain, their Parliament, according to constitutional law, comprises of the monarch, the House of Lords, and the House of Commons. And in that arrangement, what is the equivalent of Ghana's Supreme Court in the UK is actually part of the House of Lords. So it is called the Judicial Committee of the House of Lords. So in Britain, the separation of powers is not as we see in American business. So when the Americans got independence, they decided that they are going to create three separate arms of government based on Montesquieu's, scheme, and that the judiciary will be separate from the executive, and then will be separate from the legislature. And their decision was to keep the three arms at par. That is, they should all be of the same weight, the same level, so that they'll be able to check one another for a perfect balance of the government system. So we copied that arrangement and have been operating that arrangement at least more clearly under the 1992 Constitution, where we said we have three arms of government and that we rank them, apart. Each of them are the same with the Parliament. And we know that there is no way Parliament, we know that when there's a power allocated to the executive is supposed to exercise that power. When there's power allocated to Parliament or the legislature is supposed to exercise it. And when the power is allocated to the judiciary is supposed to, exercise it. There are situations where the judiciary would have to whip in line all the other arms of government. But in this particular case, the question that you always ask is, what business has the judiciary in determining the number of people who are in Parliament, in determining how many people form the majority and the minority? Now, even when it comes to the case itself, you will notice from the Constitution that even the question as to determining whether there is vacancy in Parliament, who constitutes majority and all these questions, are not even within the remit of the Supreme Court. The Supreme Court doesn't have jurisdiction to determine those matters. Those matters have been specifically handed over to the High Court to determine. So if there's, and this is clearly, if we should even take the case on its merit, you would notice that what the plaintiff was seeking to do was to question the vacancy that has been declared in Parliament. And clearly that is a preserve for the High Court, not even the Supreme Court. Yet the Supreme Court has given jurisdiction over it. Now let's go into the merit of the decision itself. So the first problem with the decision is that the court doesn't even have jurisdiction to determine that kind of matter. So the court should have declined jurisdiction. So I said that, look, plaintiff, you are here trying to question the vacancy that is declared. And the Constitution tells us clearly that when it comes to this particular issue, it is the High Court that has original jurisdiction. So you go back to the High Court and then have the matter determined. And that we, the Supreme Court, only will come in when it comes to us by way of an appeal. Yet the Supreme Court has given jurisdiction. There was no issue about jurisdiction on the matter. So let's put that aside. Having assumed jurisdiction, the decision itself it tries to give some reasons. The first of which was that the situation as it is would create political, would create, it said what? It will lead to thwarting of government business in Parliament and plunge the due management of the affairs of the country into possible disruption. So this is what the argument was, that the situation in Parliament, and what is the situation in Parliament? The situation in Parliament is simply that by the numbers that we have currently, NDC side of the House forms majority, and then NPP side of the House forms a minority. That is the situation. Now, the complaint is that this situation is going to thwart government business and is going to frustrate the running of government and disrupt the activity. But this is completely, disturbing. Do you know why? Because the framers of the Constitution know very well that there will be a situation where one party will form majority and another party will form minority. And they also know that during the course of the parliamentary term, the numbers may reduce from the side of the majority and increase on the side of the minority, thereby making the minority now the majority. And so for someone to say that the mere happening of what has been contemplated by the Constitution will frustrate government business, then the question is, what is government in the first place? What are we saying? Are we saying that the Supreme Court is saying that the Constitution doesn't intend NDC forming a majority in Parliament ever, or NDC in the middle of the parliamentary term is not entitled, or the Constitution prevents it from forming a majority, so that when NDC forms a majority, then there will be so much disruption which is not anticipated by the Constitution. So then we should reverse the situation. You understand? Like, are you getting the point I'm trying to make?
Yes, yes.
So it appears there's an entrenched position that NDC should not be allowed to form a majority in the parliament, and that whenever NDC forms a majority in the parliament, there will be chaos, there will be disruption. But the constitutional, the creators frame the constitution, they actually had in mind a skirt and blouse situation. They had in mind a situation where, in the term of the parliament, the numbers will change, making the former minority a majority. So if judges are switching, and what they are saying is that, as for us, we believe that there will be disruption in government. What kind of disruption are we talking about that has not been contemplated by the framers of the Constitution? So that is the first problem with, and that is, I think, for me, that is the biggest problem I found, that there will be such an entrenched opposition to NDC becoming a majority in the parliament, so that even if it happens naturally, as it has happened, the court will say that will amount to disruption and thwarting of government business. Unless the court's intention is that government is supposed to run the way the executive alone wants, without any interaction from parliament, without any checks and balances. But that is exactly what the framers of the Constitution intend when they say that we have checks and balances, we have separation of powers, we have multi-party democracy. Now, the second point which, I found a challenge with is the claim that the people, that is the constituents of the 4 constituencies whose seats are in question, will be disenfranchised. And then you ask yourself, why are we concerned about the disenfranchisement or the non-representation of these constituents? There are two things that will help us to answer this. The first one is that it is not the making of anybody, it is not the making of the speaker, it is not the making of the NDC side of the house, which disenfranchise or which doesn't give these individuals, these constituents a representation. It is the Constitution itself which says that when within 3 months of election there is a vacancy in the House, that vacancy will not be filled. So it is not like the situation has come up and someone is sitting somewhere and said that no, let's disenfranchise these people. In fact, what we have seen so it is the constitutional provision that actually that makes these people not represented. It is not the making of any. If it wasn't that the Constitution has placed an injunction on having a by-election, the by-election would have been hard. Compare this with what we saw in the Judicial situation, where there is no constitutional injunction, but the Supreme Court itself went out of its way to decide that they will injunct someone who has been duly elected and is representing the people, even before the court comes to the conclusion whether the person was duly elected or not. So when you put this in perspective, you see again that this claim that they want to give a representation to the people, when the Constitution itself says that those people who seats become vacant within 3 months of the election will not be allowed to have a by-election until the general election. So again, we see that side of the decision is inconsistent with what the constitutional framework itself designed or intended to be. And so, are we rewriting the Constitution, or do we think that the Constitution is incorrect, so we should rewrite it? And if we think that the Constitution is incorrect, is it the right of the Supreme Court or the power of the Supreme Court to write the Constitution, or it is a referendum that will correct the Constitution? So that is the second view. That is another view on the challenges that the Constitution, the decision has brought.
It seems from listening to you, and I know this will be a difficult thing to say, that you're saying that actually it is the decision of the Supreme Court that is inconsistent with the Constitution.
Yes, it is the reasoning of the Supreme Court which is inconsistent with the Constitution. And I've given you two instances. One, which is the jurisdictional matter, and the second one, which is the claim that the government business will be thwarted. And the third one, which is that there will be no representation for the people, because all these ones, all the three things that I've mentioned, have been explicitly stated in the Constitution. And the Supreme Court's decision on all these 3 points are contrary to what the Constitution says. And even contrary to the previous rulings of the Supreme Court action. Now, let's go to the fourth point, which has to do with what even happened in Parliament and whether it is a ruling in the sense of a ruling or is just a placing of a matter on record. So you see, the Constitution says that when an MP comes into the House on the ticket of a political party and he joins another political party, the seat will be declared vacant. That is the treatment of the Constitution. Okay. So what we have to find out is, has someone come to the House of Parliament on a ticket of party A, and we saw that all these 4 people came on a ticket or came as an independent candidate? Have they switched their political parties during the term of that Parliament? Yes, they have. If you take the NPP Constitution is so emphatic that when you are an MP or you are a member of the party, okay, and you do something which is in support of another party and against the NPP, or that you change your party from NPP, the word they use in the Constitution is that you forfeit your seat. You see, there's a difference between saying you have forfeited something and saying that you have been expelled. When they say you have forfeited, it means that you have voluntarily chosen to leave. And when you forfeit something automatically, what it means is that you don't need any ceremony to accept that you have left the party. So what has happened is that these MPs have forfeited their membership of the NPC. And once they have forfeited the membership of the party, the natural consequence is that they have left the party. So if you ask the person, has an MP left their party? Clearly, they have left their party. And if they have left their party, the natural consequence of that, according to the Constitution, is that the seat is vacant. And if you look at the wording of the Constitution, it says, well, the seat shall be vacant. It didn't say that you have to do something before it is vacant. Once the fact is placed on the record, the seat is vacant. If an MP dies, the seat is vacant. If an MP leaves the party on which ticket it comes to the House, the seat is vacant. So what the Speaker did was to place a factual matter on record. And when you place a factual matter on record, you have not given a ruling because you have not done any analysis or you have not applied any. You just put a matter on record. And when you put a matter on record, the Constitution actually gives you the natural consequence of that, what will happen. So once the matter is placed on record, the result is that it will affect the numbers in the House. And when the numbers are affected, we take a head count, and when we take a head count and we see who the person who forms the majority, automatically the person forms the majority. And if the other party group forms the minority. So what has happened in Parliament is not as if there was a contention that someone has not vacated Parliament. The facts have been put on record, and those facts are actually official facts from the Election Commission's record, which someone brought to the attention of the Speaker and have put on record. So that is the situation. You ask yourself, what did the Speaker do? The Speaker did not. The cause of the matter is not the Speaker. The cause of the matter is the MPP choose voluntarily to contest on a vehicle to join a party other than the one on whose tickets they are in Parliament. So again, you wonder what exactly the order of the Parliament of the court will be. That people have left their parties to join other parties, and the court wants them to continue to be in the House and be deciding the matter until they decide the finality of until the decision is taken. And I'm always asking myself that if the court, granted that the court is going to look at the matter, unless the court has already decided that these MPs are supposed to be in the House, but if they are not supposed to be in the house? What if the decision after the case has been heard is that they are supposed to vacate the house? What happens? Because you have asked them to come back to the house before you hear and determine the matter. Now, when they come to the house and you determine the matter, and the conclusion is the same as the conclusion of the speaker, what happens? And that is why when you are giving injunctions, courts look at the balance of the probabilities. They look at what we call the balance of inconvenience. You understand? So really, when you run through the decision, you would clearly see that perhaps the speech has affected the quality of the analysis that went into the ruling.
I see. Having said that, then, I'm wondering what you then make of the suggestions by, I'm sure you've followed Professor Koko Asari, who is of the opinion that it is the High Court that's supposed to make a declaration of the vacancy of seats.
Yes, I mean, that is the point, the first point I made, that the matter is not even within the jurisdiction of the Supreme Court. The matter is squarely within the jurisdiction of the High Court. That is what the Constitution tells us. So to assume jurisdiction over the matter is a problem. And having assumed jurisdiction, even the reasoning that went into
I understand that point, but that is because you were just dealing with what the speaker did. They were of the opinion that the speaker's move is he didn't have the authority to do that. That matter should have gone before the High Court for the High Court to determine whether or not there's grounds for the seats to be declared vacant.
No. That is not how it proceeds. The High Court is not part of Parliament. The High Court comes in when Parliament has taken a decision, and you have a problem with the decision of Parliament. Then we go to the High Court. It is not that when the case is before the court. If the case is before the Parliament, then you have to wait and go to the High Court for the High Court to confirm whether there is a vacancy or not. No. That is why they say when there is a dispute concerning the vacancy, it's not when there is a vacancy you have to go to the High Court. If the seat is vacant and it has so been declared, and someone believes that declaration is not in accordance with law, then you go to the High Court. Not that when someone alleges that there is a vacancy, and then the proceedings in Parliament will stay, and then you go to the High Court to resolve the matter before you make a decision. That is not how it went.
Now, having said that, the main question that arises now is how the Speaker of Parliament to respond to this. There are many schools of thought. What is your own view?
Yes, there are so many options. There are so many options to the Speaker. Okay, I heard one interesting option over the weekend, and I found that quite courageous. Where someone said that if it was the court that was doing something and the Speaker interfered in this manner, they would have called the Speaker to the court for contempt, on charges of contempt. So why can't the Speaker also invoke the parliamentary decision to cite people for contempt and cite the TG for contempt of Parliament? The point. Because that is one school of thought. Then there's another school of thought that, look, Parliament is doing its work, so the best of things is for the Speaker to ignore what has happened and then proceed, and the House will proceed as such. That is another school of thought, that the decision itself has not properly invoked the Supreme Court to evict it. And so if the Parliament is going to succumb to this kind of behavior, what it means is that the Speaker is allowing Parliament to be subject to the control of the court, which is not what the intent of the Constitution, the constitutional premise, says. Then there is another school of thought who said that, look, this matter is politics. It's purely politics which the court has jumped into. And if that's the case, then Parliament will play the politics with the court. But personally, I am of the view that it is not every matter of constitution which is subject to court determination. You see, the Constitution is, as we know, even we lawyers, legal scholars, and generally accepted, right from AV Dicey to American, Justice Marshall. They've all agreed that a Constitution is both a legal and a political document. In other words, the Constitution has its elements of law and its elements of politics. And it's not every element, everything that happens under the Constitution that should be sent to court or that can be resolved by a court of law. And so ABDIC, for instance, said that the matters that should be resolved by a court decision should be allowed to be resolved. Those are the legal elements of the Constitution. And then they said that there are conventional elements of the Constitution, which are matters that cannot be resolved by the court by a question of what? Politics. So, for example, he gives an example of the fact that the King, of England can dissolve Parliament. He has a legal power to dissolve Parliament without thinking of anybody, without consulting anybody. And when he does that, the court can't overkill it. But the reason why the King will not do that is because there is a convention, a political element, which is that when he does that, there will be political consequences. So the King usually will not dissolve Parliament without seeking the advice of Parliament or the Prime Minister. So if we want to subject every political situation to judicial reason, believing that the Constitution, everything in the Constitution can be resolved by law, then we are treading a very dangerous ground because Ghana is not the only constitution, Ghana is not the only country that has a constitution. And Ghana is not the only country that has this kind of constitution. All over the world, everybody knows and accepts that there are political elements and there are legal elements. Some matters must just be resolved by diplomacy, by political discussions, by compromises, by lobbying and all that. So if we sit down and everything we jump to the court and the court will assume jurisdiction over everything, the consequence is that the court is going to be seen as a political institution rather than an institution of law. And when that happens, it affects the integrity and the credibility of the court, and it affects the people's confidence in the court. And there have been instances even in this country where the Supreme Court has relinquished jurisdiction over matters and said, look, this kind of matter is not matter that the court can resolve. This is a matter which can be resolved by political mechanisms. It has happened in this country a number of times. So this situation where people, when people find challenges in the political aspect of the constitutional arrangement, and then they quickly run to court, even ex-party, and then they meet, and then they decide something which is contrary to one side, consistently contrary to one side of the divide, it is affecting the confidence of the people in the court. And you could see from the commentaries that we have been reading and listening to since Friday, it is clear that this thing has actually affected people's confidence in the court. And I don't believe that we should go that way or we should continue to go that way.
Well, always a pleasure talking to you because I love one thing you do, your careful deconstruction of the issues and then trying to deal with them one after the other. It's quite educative always speaking to you. Thank you very much. Thank you very much.
This is what we do every day.
Dr. Justice Sermsai is a lecturer at the Faculty of Law of the University of Ghana. Join us.